Alright, Chapter 27, the Government Interest in Patents. 226 is repealed. 227, time for taking action in government applications. Title 35 U.S. Standard Code 266 repealed. Title 35 U.S. Standard Code 267, the time for the actions of the government, notwithstanding with the provision of Section 133 and 151, may be extended with the time of the action of 3 years without application become the property of the United States, with the head of the appropriate of the Department of the Agency of the government, certified by the Director that the invention of the discovery of the area is important for the armament of the defense of the United States. Chapter 28. Chapter 28, Infringement of Patents. Infringement of Patents 271, temporary presence with the United States for the defense of an infringement based on the prior commercial use. Title 35 U.S. Code 271, infringement of patents, except for the otherwise provided in the civil without with authority make of the officer of the any sale of the patent with the invention of the United States, with the import of the United States, with any patent invention during the time of the patent thereof, that infringe with the patent, whereof actively induce the infringement of the patent shall be liable to the infringer, whoever the sale of the self of the United States, with the import of the United States, with the component of the patent, manufacture, combination, material of the operative of the practicing patented, process of the concept of the material of the part of the invention, knowing the same to be especially specially made and especially adapted to for the infringement, so if the patent not staple of the article of the common for the commercial, for the suitable for the substantial for the non-infringing use of liable the contributory infringer, no patent otherwise entitled to the belief of the infringement of the contribution and contributor for the infringement of the patent shall be denied with the belief of the deemed guilty for the mischief of the illegal, the extent of the patent right with the reason for the heavy done with the point more of the following, more to derive rather than new action with the perform with another with the consistent with the world against with the contributory for the infringement of the patent license with the authorizing of the perform of the act of the perform of the consent with constitute contributory for the infringement of the patent 3 for the result of the enforcement of the patent right against for the infringement of the contributor and infringement 4 refuse the license with any of the rights of patent 5 the condition life with any of the rights of patent with the sale of the patent production the acquisition life with the rights for the end other patent purchase with a separate product with unless with the review of the circumstance patent owner of the market with the power of the relevant market of the patent product on which the license or sale with the condition it shall not be active with infringement within the law to sell with the United States and import with the United States with the patent invention, otherwise the new animal, drug, veterinary, biological property, all those terms used with the Federal Food, Drug, Cosmetic Act with the Act of March 4th, 1913, which was primarily manufactured with the recombinant DNA, recombinant RNA with the hydrium technology, other process involved specifically genetic manipulation solely for the use of the responsibly with the developed information from the federal law, regulates manufacture, use, of sale of the drugs and veterinary biological products. It should be an act of infringement, submit it, and action under Section 505J of the Federal Food, Drug, Cosmetic Act described in Section 505B2 with the act of the drug and patent, the use of which claim patent. Applicant under Section 512 of the Act under the Act of March 4th, 1913 for the drug and veterinary biological product of the primary manufacturer, recombinant DNA, recombinant RNA, hydrogen technology processes involving site-specific genetic manipulation techniques claimed of the patent for the use of the claim patent. Respect for the person patented with the license list of patents, Section 351.13 for the Public Health Service Act, an application seek for the proof of the biological property if the applicant failed to provide application information required within Section 35.1.2a of the Trust Act of the application such for the proof of the biological property of the patent could be identified pursuant to Section 35.113a1 of such act of the person such submission for the obtainment of approval of the such act of the engaged with the commercial manufacturer use sale of the drug, veterinary, biological product claim patent of which you the claim of the patent before the expiration of such patent and any act of the patent infringement brought within the section of the non-injunction for the other relief for the grant with the prohibited making you for the offering shelf of the selling with the United States with the importing the United States with the patent and invention with the paragraph 1. For act of the infringement described in the paragraph 2 of the court with the offer to the effect of the day of the proof of the drug of the veterinary of the biological property involved with the infringement of the date with not earlier with the date with the expiration of the patent has been infringed. B. Injunctive of the relief of the granted against with the infringer of the prevent with the commercial manufacturer of the sale of the United States with the importation of the United States with the proof of the drug of the veterinary biological property of the biological product, damage of the monetary relief of the award of against the infringing officer for the head of the commercial of the manufacturer officer to sell of the United States with importation of the United States with the proof of the drug of the veterinary biological product. The court shall order permanent injunction of the prohibiting an infringement of the patent biological product involved with the infringement of the day within the day of the expiration of the patent infringed on paragraph 2C of the patent and subject to the final court decision to define section 351 case for the Public Health Services Act of the action of the infringement patent under section 35(1)(a)(6) of the biological product that has been approved by section 351 case of such act. The remedies prescribed in paragraph A, B, and C with the D with the remedy for the granted with the court for the infringement of prescribed in paragraph 2, except that the court may award attorney fees under section 285 when the person that filed the application described in paragraph 2 would include the certification subject for the B2A4 or J274 section 505 of the Federal Drug Cosmetic Act with the need of the owner of the patent with the subject of that certification holds over the proof of the applicant subject B with the subject section of the drug with the claim of the patent, the which of the claim of the patent brought with the action of the infringement such patents before the expiration of the 45 days after the date with the notice of the given the notice subsection B3 with the J2 B2. So the section was received of the court of the United States shall the extent with the consistent with the Constitution have subject to the matter jurisdiction of the action brought with the choice for the person and with the section 2201 Title 28 the declaratory judgment of the such patent is invalid and infringed. 6A subparagraph B with apply with the lieu of the paragraph 4 in the case of the patent and they identify the applicable list of the patents described in the 35(1)(4) of the Public Health Services Act with the list of the patents described in section 35(1)(1)(5)(b) with such act with the biological product which for the infringement of the patent with the restrict the biological product with the expiration of the 30-day period with the described in the paragraph subparagraphs A and B with the applicable section 351(1)(6) of the such act with the A2 that was brought with the expiration of the 30-day period with the described in the clause 1 which with the dismissal of the prejudice did not prosecute with the judgment in good faith with the inaction with the infringement of the patent described in paragraph A so exclusively readily with the granted with the court with upon finding of the making using and selling importation of the United States of the biological product with the subject of the action infringed patent with reasonably royalty. The owner of the patent should have the include with the described with the section 351(1)(3)(a) with the Public Health Services Act include with the provider under section 351(1)(7) with the act and biological product was not similarly included in the section of not bringing action in the section of the infringement of the patent in respect to the biological product. 501. Whenever the without authority supply with the comes to the supply with the United States with the substantial with the portion complements with the patent invention with the the components of the community come combine the whole and impart in such a manner with the actively induced combination of such components outside the United States in a manner with the infringement of the patents in some combination occur with the United States with the be liable to infringe. 2. Whatsoever without authority supply with the cover the supply with the firm of the United States with the component with the patent inventory especially made especially at the top of the with the invention with no stable article with the commodity with the commercial suitability with the substantial and non-infringible use, whereas those components uncombined with the whole and apart with the known such with the components made with adaptive with the intent with the stuff with the components will be combined with outside with the United States and a man with the infringe of the patent and such with the combination occur with the United States shall be liable to infringer. G. Whosoever without authority in the import of the United States with the offers to sell with the use of the United States with the product with the made with the process patent with the United States should be liable to infringe with the important officer with the sale with the sale with the use of the product with the occur with the during with the process with the action and infringement of the process patent with the remedy that may be granted for the infringement on an account with the non-commercial use of the retail sale of the product useless unless no adequate remedy for the title infringement of the account with the importation off the sale of the product that made with the patent process will for purpose of the title not be considered to be made after the material charge in subsequent processes or items by triple the non-essential component with another product. As within section, whoever but included any state instrumental stand with any officer employed with the state with the instrumentality state acting on his official capacity and state with the instrumental officer employee, with the division with the title of the same manner with the same with the non-governmental entity. Used in the section offered for sale of the offered or sell the person offered than the patentee with their signing of the patentee that which in the sale will occur will before the expiration of the term of the patent. Title 35, U.S. Standard Code 272, temporary presence of the United States. Use of the invention, use of any vessel with the aircraft, the vehicle, with the aircraft, with the forward, with the sum of the privilege of the vessel, aircraft, the vehicle, with the United States, and with the United States, with the temporary accidental, which are not exclusively constitute with the infringement of the patent. Here with the mention is not exclusive for the needs of the vessel, aircraft, of the vehicle, with not offered for the sale or sold with the use of the manufacturer, anything to be sold with and exported aided in the United States. Alright, Title 35, U.S. Standard Code 273, the defense for the infringement based on prior. In general, personal and tell with the defense within under Section 282, be with the restrict with the top of the man with the existing with the process with the consider with the machine with the manufacturer with the composition man with the manufacturer over the commercial purpose with the otherwise with the infringed claim with the invention with the serve with the against the person if the trust of the person acting with a good faith of the commercial use of the subject matter of the United States, either the conjunction of the internal commercial of the actual arm's length of the tail of some or lengths commercial transfer the useful and resolve of the commercial use of the commercial occurs at least 1 year before earlier either. Effective following the date of the claim and the date of which claim and invention with the discovery of the public domain with the qualified with the exemption of the prior with the art with the 102 with the burden and proof the part asserting with the defense with the under the section you have the burden establishing with the defense with the clear convincing evidence. C. The additional commercial use of the pre-marketing regulatory review subject matter with the commercial market use of the pre-marketing regulatory review determining with which safety efficiency subject matter establishment included within any of the period in section 156G shall the deemed the commercial within the purpose of the subsection A of the 1 of the during such regulatory review period of the non-profit laboratory use of the subject matter of the non-profit research laboratory with the non-profit in the such university hospital for which the public intended beneficiary should be deemed to be for the commercial for the purpose of the section A1 except for the defense for the section with the asserted pursuant of the paragraph continued non-commercial use in the laboratory for another non-profit entity with the extension exhaustion right for the sound statement subsection E1 with sales of the other disposition useful end for the person entitled for the distributor the defense of the section with the connection with the patent in respect of the useful end result so exhaust the patent or resolve the patent to the extent of the set of the rights for the exhausted had to such sale of the other disposition had made with the patent owner. Limitation exemption. Personal defense in general, the defense under the section may distribute the person performing the direct with the performance commercial use with described in subsection A of the end, either the control of the under of the commercial control of such person. Transfer of the right, except for the any of the transferred patent owner of the right of the defense of the section not licensed to sign with the transfer of the any other person except for the ancillary subordinate part of the good faith of the sign of the transfer of the other region with the entire of the enterprise of the line of business the defense relates. Alright, C. The restriction on site of the defense of the section of the quiet of the person part of the assignment of the transfer of the described in subparagraph B may only be distributed to the use of the site of the subject matter of the otherwise infringe of the claim and invention of the use of the later for the effect of the filing date with the claim and invention of the date of the assignment transfer of the such within the private of the business. Derivation, a person may also the defense under the section of the subject matter of the defense of the based on the derive of the patenter and for the person with the privacy of the patenter. Not a general life of the defense of the serve of the person under the second of the general license on their claim to the patent issue, but extent of the items extends only of the subject's specific subject matters for which it has been established with the commercial use of the qualified zone of the section occurred, except for the defense of the extent of the variation quantity. Following use of the claim subject matter of the end to improve the claim subject matter of the do not infringe additional specified claim subject matter of the patent. Abandoned use of the person who have the abandoned commercial use of this qualified zone of the section subject matter that may not rely on activity permanent warm before the date of such abandonment of the establishing date found zone of the section with respect to the actions taken on and after the date of such abandonment. Alright, 5. University exemptions. In general, person commercially subject to the matter in subsection A of the apply within the serve of the defense of the section training invention with respect to the defense of the serve of the time of the invention of the home of the subject of the obligation assignment in the institution. Higher education of the Higher Education Act of 1965, the technology transfer organization primary purpose is to facilitate commercialization of the technology developed in one or more such institutions of higher education. Exemption some paragraph A shall not apply to the activity required to reduce the practice of the subject matter claim and invention could not have been undertaken to tap funds provided by the federal government. If unreasonable assertion of the defense, if the defense under the section is believed with the person who have found infringement patent and then subsequent failed to demonstrate the reasonable basis for asserting the defense of the court shall fund the exemption with the purpose of awarding the attorney fees under section Title 35 U.S. Standard Code 285. Invalidity of patent should be deemed to be invalid under section 102, 103 solely because of the defense raised it and established under section. Chapter 29, Remedies, Infringement of Patent and Other Actions.